and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hi, Richard.
Hello, Lizzie. How are you?
I'm very well, thank you.
We're still cold here, just like the last time we did a podcast.
Yeah, we haven't escaped the snow and the cold weather just yet. We're here to discuss, we had a webinar a week or more ago now, where we had a lot of questions. It was one of our biggest audiences to date. So understandably, we didn't get through everything. So we've got a few to cover, well, more than a few probably to cover now, so that we make sure we cover off all the questions that were asked of us. The webinar was on the Landlord and Tenant Act 1954 and specifically on grounds of opposition and renewal terms. So let's just go straight into it with one of the first questions. When is the effective date of the 5-year rule, i.e. is it at the time of the notice?
This is the 5-year rule in relation to not being able to use ground G, occupation for human purposes. If you purchase the property subject to a protected tenant in the last 5 years, or someone whom your interest merges with, it's actually in section 30, subsection 2. It's the 5 years prior to the termination of the tenancy under the Act. Basically, it's the earliest can be the end of the fixed term, but with that proviso, the end of any section 25 notice period or section 26 request. Yeah, so not the time you go to court and the likes. The earliest that the end of the termination of the current lease.
A question here on section F. If somebody wishes to undertake considerable refurbishment within a building that requires the tenant vacates, say, for example, putting in a new roof, does the tenant have any grounds to say, okay, but once the refurbishment is complete, we want a new lease at that point?
Short answer is no. But you can. Ground F is demolition and reconstruction. There are question marks over, for one, what constitutes demolishing, reconstructing, or carrying out substantial works necessitating the tenant's removal. And there are lots of cases over many years that depend very much on their individual facts. And I can see how replacement of a roof would be too much. There was a case that I didn't mention. It's a House of Lords case from 1973 called Heath and Drown, which said that the landlord couldn't use ground F if they had the ability to enter and carry out the works anyway. The lease allowed them to do so. And also it's in section 31, not 30, subsection 1, but 1 and capital A of the Act. If the tenant can agree to an inclusion of terms in the new lease allowing the landlord access, so the landlord can carry out the works that way and reasonably be able to do so, then the court won't award a renewal. Won't award a successful opposition. So that's a possibility, but with those provisos, once the landlord succeeded on ground F, the tenant's not entitled to a new lease.
Are you aware of any cases where the purchaser of a freehold subject to an expiring 54 Act lease operates the same business as the tenant? And would the court consider granting a renewal lease of 5 years duration to enable the purchaser to serve an opposed notice G when they have accumulated 5 years ownership?
It's a well-known ploy, actually, that landlords running the same kind of business use ground G to get the tenants to do all the dirty work. I think I mentioned it in the course, actually. Not always. There have been cases for certain, if not fully reported cases on things like restaurants and the likes, where the landlord runs a similar business. There was one where they actually failed on the fact they didn't have the necessary intention or couldn't show they had the necessary intention. But it's definitely, the case that it happens.
The next question, if rent is paid quarterly and a tenant has unilaterally paid monthly with the landlord accepting this, is that a delay in paying rent?
I presume this is in the context of ground B, which is persistent delay in paying the rent. I would imagine almost certainly, if not certainly, if the landlord has knowingly accepted the rent monthly, the as opposed to quarterly and not sent the money back, that is not a persistent delay. You'd have an estoppel on your hands. Landlords led the tenant to believe that there's no breach. For things like forfeiture, the landlord would have waived any right to forfeit anyway. And ground B depends on the court has a discretion. It's got to be such that the tenant ought not to be granted a new lease. And you'd argue in those circumstances, tenant ought to be granted a new lease, basically.
So the next question we have here, so first scenario, they have a 10-year lease with a break at year 5. The second scenario, they have a 5-year lease and an option to renew. If they renew, I presume they mean for another 5 years as part of their option, how does SDLT, etc., differ for this same 10-year period?
Well, stamp duty, land tax, and also land transaction tax in Wales, mustn't forget that. You pay on the, amongst other things, the duration of the lease. The longer the duration, the bigger the tax liability. And a 10-year lease with a 5-year break. If you exercise the break after 5 years, there's still a 10-year lease. So you've got a big tax payment up front. A 5-year lease with an option to renew, a contractual option to renew, is a 5-year lease. So you pay less tax and might even not pay any tax whatsoever. It's a much better bet, although breaks tend to be the norm. If you exercise the option to renew, I've seen the revenue argue it's a linked transaction for tax purposes. So you have to link the two together and it'll be the same as a 10-year lease, let's assume. Tax thresholds haven't changed in the meantime. I'm not sure that argument's right. And in fact, I think it's wrong. I have seen them back down on that, but don't take me up on that. And it's still a much better bet because you don't have to pay all the tax up front. You have to pay it after 5 years, if you do have to pay it, which I don't think you do. But perhaps if you can't afford to pay the tax 5 years down the line, it's probably best if you don't exercise the option because your business is not doing particularly well. That's basically it.
Thank you. The next question, please, can you explain when the interim rent is backdated? Is it to the end of the contractual term under the lease, or is it to the date 6 months after the Section 25 or Section 26 notice is served?
It's not the best drafting. It all changed in 2004 when the 2003 business tenancies order came into force. And it isn't well drafted, but it seems, I think people accept, it's the earliest that you could have put in the Section 25 notice or the Section 26. And the earliest, the shortest Section 25 notice is for 6 months. So it's, 6 months after the Section 25 notice is served, which might be the end of the fixed term, if it's served as early as you can. But that seems to be the what people have sort of accepted.
Thank you. Could you elaborate a little bit more on out of the zone of contemplation and how courts or solicitors would approach identifying the zone of contemplation?
Yeah, it's Cunliffe and Goodman 1950 case, which wasn't actually on, it's my favourite quote in the whole of property law. It wasn't actually a case on the 54 Act, it was all about limitations of damages, landlord's damages, the disrepair under Section 18 of the 27 Landlord and Tenant Act. And Lord Justice Asquith, as he was, said that you have to have a right which is out of the zone of contemplation into the valley of decision. This has been taken up by 54 Act grounds of opposition F and G. Demolition, reconstruction, occupation for your own purposes. It has to be clearly thought out. It's not just tentative or exploratory. Now, there's a case we did a podcast on last year, if you remember, BMW Holdings, BMW Holdings and K Group, which is a car dealership in Park Lane in London, where they wanted to basically include a landlord's break in a new lease because they had some vague idea that in the duration of the lease they might want to take over a business from the same premises, converting luxury cars into hybrids. And they admitted it was only tentative, they hadn't thought it through. And that was held to be, well, I think the word was inchoate, my word of the day.
That's a great word, yes.
Inchoate. not well thought out. You also got to have a clear possibility of bringing about that desire. But it is pretty vague, I'll admit.
The next question, does a landlord's occupation also include a group company of the landlord occupying?
Yeah, it's again, ground G, it's if you've got a controlling interest over the landlord, or the landlord's got a controlling interest, or the group's got a controlling interest over the landlord, you can still use ground G, subject to, again, the 5-year rule.
Thank you. And one of the cases you mentioned in the webinar, Dolgethley Golf Club.
You pronounced it right.
I did, just about, didn't even trip up on it. In that case, would the tenant be compensated?
They could be compensated because the landlord was using, as it happens, the landlord lost the case because the tenant had their clear intention, albeit doomed to failure. Controversially, the Court of Appeal didn't reverse the first instance decision on that. But if the landlord had succeeded, then you could have got compensation for disturbance based on rateable value. Yeah.
Okay, next question. Can a landlord use ground G to refuse a commercial retailer's lease renewal when the landlord wishes to convert the property to residential? If so, could it then be sold off on a long lease?
It's the landlord has to want to occupy for their own business or residential purposes. I think in those circumstances, the landlord will probably be better off using ground F and showing an intention to demolish, reconstruct. There was a controversial case earlier this year, actually, that we did do a podcast on this, and you can look. You remember Royal Borough of Kensington and Chelsea and Melcraft, where to cut a long story short, the council, I think it was in the notes, but we didn't talk about it, didn't have time, but the council wanted to gain possession of this property in Portobello Road, which was a commercial premises on one floor and residential on the other, which if it's mixed use, then it comes within the commercial regime. And they wanted to put homeless people temporarily in the property under their obligations to temporarily house the homeless, pending a decision as to whether they're entitled to more permanent housing. And the court decided, amongst other things, that you don't intend to occupy yourself, but you intend to, occupy the people who are going to occupy these, otherwise homeless people. That failed. But I think ground F would be a better bet there.
Okay, next question. Can a landlord oppose a renewal if the tenant exercises a contractual option to renew that is within the lease?
Well, if you've got a contractual option to renew, that's going to clinch you. It's not a bad idea, actually, to have certain types of tenants where landlords, I know what the big time players, got perhaps smaller premises, but kind of fairly sort of blue chip companies and likes will do is just that. So if the landlord uses an on false ground against your F or G, say, is incredibly rare, then you can always exercise the contractual option. So yeah, it's not a bad idea at all.
The next question's not really about grounds of opposition, but if a tenant serves a Section 26 notice and they won't extend the deadline, are they allowed to serve a Section 27, or have they forfeited this option and must leave on the date stated in the Section 26?
There's Section 27 has the ability to give 3 months notice no earlier than the lease coming to an end for the purpose of the end of the fixed term tenancy. But there was a case, actually, it was under pre-2004 changes to the 54 Act, but a case called Single Horse Properties, I remember, Surrey County Council, where they served a Section 26 request and then decided that they, terminating beyond the end of the fixed term of the tenancy, and then they decided they would vacate anyway before the end of the fixed term of the tenancy. And the court said you could do that because the Act doesn't apply, because you've got to occupy, under a lease at least partly occupy for business purposes. And if you vacate, then you're not bound by the Section 26 request anyway. So you could presumably do that. You might just lose your compensation for disturbance, depending on what grounds, if the landlord's opposing. But yeah, it seems a distinct possibility. You don't even have to give 3 months' notice.
On ground A, how is ground A if the tenant has made up all back rent by the time the lease ends?
Well, it's persistent delay in paying the rent, which doesn't mean to say, you're necessarily in arrears at the time you go to court or whenever. But that Gill and Lee's case that we talked about, Lee's News, basically said that, mentioned it, I think earlier, that it's got to be such that the tenant ought not to be granted a new lease. So you have to take into account the tenant's needs and wishes as well as the landlord's. And on the facts, the tenant had solved the disrepair problems and the rent arrears, and the tenant ought to be granted a new lease. I think a lot of tenants at the moment have been arrears with their rent because of, in the retail, hospitality, leisure sector, because of the various lockdowns. And I'm sure the courts would look favourably on that.
Thank you. The next question is, isn't it uncommon for a landlord to have to break in a protected tenancy? And how does compensation work if the landlord actions that break?
Well, it's more common than you might imagine. If you think you want to develop the site, the most obvious thing to do is exclude the 54 Act. But if you get cases like some of the ones we mentioned, B&M and HSBC pension trustees, another one we've got a podcast on, where for whatever reason the tenant's successfully entitled to a new lease and then the landlord includes a development break, it's not a bad idea at all to argue that. The court seemed very favourable. The first case, and it was a case called Reahorn and Barry Corporation in South Wales. And that was from 1956, I think, the early days of the 54 Act. So perhaps more common than you imagine.
Thank you. The next question is it possible to renew terms under the Act if a lease never existed, but the tenant has been in occupation for many years, keeping the premises in repair, occasionally paying the landlord sums of money for various repairs and bills, etc.? Could that tenant then serve a Section 26 to secure a lease?
Now, a lease does exist. It's just not nothing in writing. If you haven't got any agreement whatsoever, and you start paying your rent quarterly or whatever it might be, you'll have a periodic tenancy implied, so the lease does exist. And they're quite dangerous, actually, because people don't realise, this is happening. And the landlord can't serve the 54 Act warning notices. You can't, it's too late anyway, but also the only thing you can exclude is a fixed term tenancy in the Act. The landlord could ask for a lease renewal in those circumstances.
Can you please repeat the case law you mentioned about breaks in a protected lease?
Yeah, there's a couple of them, actually. One was called Weinberg's Weatherproofs and Radcliffe Paper Mill, but the main one, it's a 1960s case from 1967. Scholl Manufacturing and Clifton Slimline is the case, which basically said that if you've got a landlord's break, like a development break, in a 54 Act lease, and you exercise as a landlord the break, then all you're doing is accelerating the 54 Act continuation. The tenant's still got security. But if you make the landlord's break 6 to 12 months in duration, the same duration as a Section 25 notice, you've killed two birds with one stone. The Section 25 notice is also the landlord's break, and you can at the same time oppose a new lease, presumably most likely on ground F, you want to demolish, reconstruct. Scholl Manufacturing, Clifton Slimline, SCHOLL.
Okay, thank you very much. With landlord redevelopment breaks, would the tenant be compensated? And if redevelopment includes new retail space, does the tenant have priority for occupation of the new space?
Yeah, the tenant can claim compensation for the disturbance. And the tenant, I think we sort of went through this a bit earlier on, actually, but the tenant wouldn't be entitled to a new lease. No.
In what cases would including turnover rent in the lease renewal be advantageous to the tenant?
Well, it became topical a few years back in the aftermath of the lockdowns, because turnover rents are based, or part turnover rents are based on your profits. So if your profits plummet, then you don't pay less Oh, so you don't pay as much rent. So they can usually be favourable to tenants. They're also sort of, tenants who are starting up in business. You don't want to pay a full market rent, so you might consider it there. That W3 GP and JD Sports case, as it happens, it was a lot more favourable to the landlords. I'll leave the valuers to tell me why. In that case, they can't normally, unless the parties obviously agree, have a turnover rent on the 54-hour renewal anyway.
Okay, can a tenant argue successfully for a renewal that downgrades the lease from a full repairing to an internal repairing lease?
Well, that's section 35 of the Act and the House of Lords case from 1983, O'May and City of London Real Property Company. You're supposed to have regard to the terms of the current tenancy. And unless the parties agree, I think that would be highly unlikely that the tenant could get that, even if it was reflected in the rent.
Okay, penultimate question. We're nearly there. What rent is paid? What rent is paid if the lease has ended but no notice has been served by either party?
The rent will continue as it was, subject to having things like end of term reviews and the likes. The rent just will continue. If then one of the parties serves a Section 25 notice or a Section 26, you can apply for an interim rent, backdated, as we talked about previously. It's always in the tenant's best interest. If rents are falling, you serve a Section 26 request, and if rents, it's a downward rent review basically. And if the rents are rising, landlords should be serving Section 25 notices. But you come across situations when people just forget about it years later, nothing's happened. If the rents are falling, it's in the landlord's best interest to keep quiet.
Okay, and we are here at the last question. If an occupier has been operating their business at a premises for 30 years but without any lease in place, and the landlord is now trying to evict them on the grounds of E, F or G, would they get compensation?
Yeah, I mean, they have got a lease in place. It's just not a lease in writing. It is, as we mentioned previously, based on periodic tenancy, and that is how you pay your rent. And you're entitled to compensation for disturbance. Most leases exclude compensation for disturbance, but that exclusion is void if the tenant can show 5 years occupation before the lease came to an end for the purpose of the Act. And you get double rateable value if the tenant can show 14 years. So within those provisos, it's no different. They'll be entitled to compensation. I've seen it happen. I've seen a lot of tenants who don't realise they're entitled and just leave anyway.
Brilliant. Well, that's it. Thank you very much, Richard.
Thank you, Lizzie. Now I'll have a lie down.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.